2:14 p.m. Eastern Standard Time, Federal Courtroom, Southern District of New York. The gavel cracks like a gunshot. Judge Helena Cartwright doesn't hesitate, doesn't blink. Her voice cuts through the marble chamber with surgical precision. A bail is hereby revoked. Effective immediately, the defendant's face drains white. Lawyers freeze mid-sentence. And then it happens. The side door explodes open. United States Marshals fled the well of the court like a tactical unit breaching a compound. No warning, no grace period, no appeal. This isn't procedure. This is justice moving at the speed of fury. Within 90 seconds, steel bracelets click around wrists that signed million-dollar deals just hours ago. The courtroom erupts. Reporters sprint for exits. Camera shutters fire like automatic weapons because what just happened doesn't happen in America. Not to people with this kind of power. Not to defendants with 8-figure legal teams and friends in Congress. But it just did. And the shockwave is about to rip through Washington like a Category 5 hurricane making landfall at rush hour. You need to see this right now, before the entire narrative gets sanitized, spun, and buried under legal jargon designed to protect the guilty. Hit that subscribe button. Smash notifications, because what unfolds in the next 10 minutes will rewrite everything you think you know about accountability in this country. This is the moment the system either proves it still works or confirms it's completely broken. And you need to be here for every second. The defendant isn't some low-level operative. We're talking about every third figure who walked the halls of power like they owned the deed to the building. Someone who took calls from senators, dined with cabinet members, and operated in circles where justice was something you negotiated. Not something that actually touched you. For 18 months, federal prosecutors built a case so airtight it could survive a nuclear blast. RICO charges. Wire, fraud, spanning 17 states. Conspiracy to obstruct justice. Evidence so damning that seasoned defense attorneys took one look at the discovery and started plea bargaining before indictment ink dried. But bail was granted anyway. Standard protocol for white-collar defendants. Post the bond, surrender passport. Wear the ankle monitor. Play golf while your lawyers file motions until the heat death of the universe. Except someone made a catastrophic miscalculation. Yes, the violation wasn't subtle. It wasn't a technicality buried in subsection 4 of a Pitrial release agreement that nobody reads. This was brazen, reckless, the kind of arrogance that only comes from decades of watching consequences apply to everyone except you. Federal monitoring systems flagged the breach at 11:47 p.m. 3 nights ago, the ankle monitor registered movement outside the authorized perimeter, not by inches, by miles. Cross-state travel. Encrypted communications with co-conspirators explicitly prohibited under bond conditions. And here's where it gets absolutely nuclear: attempts to liquidate assets and transfer funds to offshore accounts in the Cayman Islands while under active federal surveillance. They weren't just violating bail terms. They were actively destroying evidence and preparing to run. Prosecutors moved like a SWAT team hitting a methamphetamine lab. Emergency motion filed at 6:38 a.m. supporting documentation. 214 pages of intercepted communications. Bank transfer receipts and GPS tracking data that reads like a spy thriller. By 9:15 a.m., Judge Cartwright's chambers received the filing. By 10:45 a.m., her clerk issued an order. Emergency hearing scheduled for 2 p.m. No continuances, no delays. Defense counsel scrambled. Phones detonated across 3 law firms. Senior partners who bill 4 digits per hour suddenly had 4 hours to construct a defense against evidence that proved their client treated federal court orders like suggestions at a buffet. Inside the courtroom, you could taste the panic. Defense table looked like the final scene of a disaster movie where everyone realizes the escape plan just collapsed. Lead counsel Richard Peaton, Harvard Law, 42 years of white-collar defense, reputation built on keeping billionaires out of handcuffs, stood up, and you could see his hands shaking, not trembling, shaking. His opening argument lasted 90 seconds before Judge Cartwright cut him off mid-sentence. Counselor, I've read your submission. I've reviewed the government's evidence. Unless you're about to tell me those GPS coordinates are fabricated and those bank transfers are deep fakes. Sit. Durton sat. The courtroom went silent. That's when you knew this wasn't a hearing. This was an execution. Assistant Prosecutor Michael Chen stepped to the lectern. 39 years old. Princeton undergrad, Yale Law. 7 years in the Southern District, putting away organized crime figures and corrupt hedge fund managers. His reputation, zero theatrics, maximum precision. He didn't raise his voice. Didn't need to. Your Honor, the defendant has demonstrated conclusively that they view this court's authority as optional. On November 18th at 2040, 7 hours, monitoring systems recorded unauthorized movement. The defendant traveled from their residence in Greenwich, Connecticut, to a private airfield in Teterboro, New Jersey. Surveillance footage shows the defendant boarding a chartered Gulf Ream registered to a shell corporation in Delaware. Flight plan filed for Nassau, Bahamas. The aircraft was wheels up when federal agents intercepted at the runway threshold and forced the pilot to abort takeoff. The courtroom detonated. Gasps rippled through the gallery like shock waves. Reporters' fingers blurred across phone screens. This wasn't bail violation. This was attempted flight from prosecution. Chen wasn't finished. Additionally, between November 16th and November 19th, the defendant initiated wire transfers totaling $47 million to accounts in Grand Cayman, Singapore, and the British Virgin Islands. Financial forensics confirm these transfers were designed to place assets beyond the reach of seizure orders. Further, intercepted communications reveal the defendant contacted 3 individuals currently under indictment in related cases, directly violating no-contact provisions. We have recordings. Chen pressed a button. Speakers crackled to life. The defendant's voice filled the courtroom. Clear. Unmistakable. We need to align stories before deposition. The prosecutor's building. Obstruction. But they can't prove intent if we're coordinated. Delete everything from the September meetings. Use the encrypted app we discussed. 11 seconds. That's all it took. 11 seconds of audio that obliterated any possible defense. Peaton looked like he'd been hit with a cattle prod. His co-consul was physically pale. The defendant stared at the table, jaw clenched. Reality finally crashing through layers of entitlement like a wrecking ball through drywall. Judge Cartwright leaned forward. Her expression could etch glass. Mr. Peaton, does your client have anything to say before I rule? Peaton stood, opened his mouth. Nothing came out. He tried again. Your Honor, there are mitigating circumstances that Cartwright's hand came up. Full stop, Counselor. Your client was caught on a runway attempting to flee the country. Your client transferred $47 million offshore while wearing a court-ordered monitoring device. Your client conspired to obstruct justice on a recorded line. There are no mitigating circumstances. There is only contempt for this court and the rule of law. The gavel came down like a guillotine blade. Bail revoked. The defendant is remanded to federal custody immediately. Marshals take them into custody. That's when time fractured. The side door burst open. 4 United States Marshals, tactical gear moving with coordinated precision that comes from executing high-risk warrants on dangerous fugitives. Except this wasn't a cartel kingpin. This was someone who had lunch at the Four Seasons last Tuesday. The lead marshal approached the defense table. "Stand up, hands behind your back." The defendant looked at Peyton. Peyton looked at the ceiling. No rescue coming. No procedural miracle. No emergency stay from an appellate court. The defendant stood slowly, like maybe moving in slow motion would stop what was happening. It didn't. Handcuffs clicked into place with a sound that echoed off marble walls like a church belling. And then the perp walked through the gallery, past reporters, cameras capturing every microcond. The fall from power condensed into a 15 second-on journey from defendant's table to a reinforced door that leads to the holding cells beneath the courthouse. This isn't unprecedented, but it's rare. Extraordinarily rare. We're talking about a microscopic fraction of federal cases where bail gets revoked mid-trial preparation. Professor Angela Morrison, Constitutional Law, Georgetown University, 43 published papers on pretrial detention. When a federal judge revokes bail after initial grant, especially in a white-collar case, it signals something catastrophic. It means the defendant didn't just violate technical conditions. They demonstrated active, ongoing danger to the integrity of the judicial process. Judges don't make these calls lightly. The evidence has to be overwhelming, and the threat has to be immediate. What we're seeing here is a complete breakdown of the defendant's relationship with reality. Historical precedent vanishingly small. Bernard Madoff had bail revoked in 2009 after prosecutors proved he was mailing jewelry and financial instruments to family members in violation of asset freeze orders. Bail yanked, remanded immediately, he never saw freedom again. Sam Bankman Freight FTX collapse had bail revoked in August 2023 after witness tampering became undeniable. Judge said enough. Marshals moved in straight to Metropolitan Detention Center, Brooklyn. That's the company we're talking about. Not low-level offenders, not street crime. This is reserved for defendants who prove they cannot be trusted even under the most privileged form of pretrial supervision. The political fallout is thermonuclear. Within 90 minutes of the courtroom scene, congressional offices erupted, phones ringing off hooks, staffers scrambling to draft statements because this defendant wasn't operating in a vacuum. Campaign contribution records show donations spreading across both parties like a contamination map. Fundraisers attended, policy meetings held, influence purchased in bulk. Senator Margaret Thorne Judiciary Committee issued a statement at 4:47 p.m. slice. Today's revocation demonstrates that no amount of wealth or political connection places anyone above the law. This committee will investigate any and all relationships between the defendant and current office holders. Translation: everyone who took money, took meetings, took favors, is now in the blast radius. Opposition research teams are pulling files, ethics investigators sharpening knives. Competitive primaries suddenly have nuclear ammunition. Former federal prosecutor David Craner, 26 years Southern District, now teaching at Harvard Law School, went on record. The judge's decision to revoke bail and order immediate remand sends an unmistakable message. The defendant exhausted every benefit of doubt. They were given freedom, monitoring, and conditions designed to balance liberty with public safety. They chose to weaponize that freedom to obstruct justice and prepare for flight. At that point, petrol detention isn't punitive. It's necessary. The system gave them rope. They tried to use it as an escape ladder. That doesn't end well. Craner's analysis cuts deeper. What we're witnessing is accountability delivered in real time, not months of appeals, not procedural delays engineered to run out the clock. A judge looked at evidence, made a ruling, and enforcement happened instantly. That's how the system is supposed to work when it actually functions. The defendant is currently housed at Metropolitan Correctional Center, high security federal detention facility. No bail, no house arrest with private chefs and tennis courts. Standard issue jumpsuit, standard issue cell. 20. 3-hour lockdown protocol for high profile inmates at risk. The ankle monitor that tracked their attempted escape. Cut off by marshals and logged as evidence. The private jet fueled and ready at Teterboro, seized under asset forfeit statutes. The offshore accounts in Grand Cayman, frozen by international banking cooperation agreements, triggered the moment prosecutors filed emergency motions. Every escape route, every contingency plan, every backup scheme built over months of preparation, collapsed in 140 minutes of judicial reckoning. And here's the absolutely critical element that cannot be overstated. This revocation fundamentally alters trial strategy. Defendants were building their entire approach around a client who could coordinate, who had access to resources, who could sit in strategy sessions and review discovery and comfort. That's gone. Communications now happen through reinforced glass. Legal visits are monitored. Documents reviewed under guard. The psychological impact alone is devastating. Professor Morrison again. Pretrial detention changes everything. The defendant goes from preparing for trial in their own environment to preparing from a cell. The pressure is immense. Plea negotiations that seemed unthinkable last week suddenly become attractive when you're facing months or years of detention before trial even begins. We are witnessing a constitutional stress test in real time. The framers designed a system with checks and balances precisely to prevent tyranny, but also to prevent the wealthy and powerful from purchasing immunity. What happened at 2:14 p.m. in that courtroom is the judiciary asserting its authority against a defendant who believed connections and capital could insulate them indefinitely. This isn't political theatre. This is the constitutional order defending itself when a federal judge revokes bail and marshals execute that order within seconds. The message reverberates through every corridor of power. The law still means something. Violations still carry consequences, and no amount of influence rewrites that fundamental truth. The defendant's legal team will appeal. Motions are already being drafted. Emergency petitions to the Second Circuit Court of Appeals. Arguments about procedural irregularities, due process violations, disproportionate response. Every legal maneuver that exists will be deployed. But here's the brutal arithmetic. Appellate courts give enormous difference to trial judges on bail revocations. The standard is abuse of discretion. When you have GPS evidence of attempted flight, recordings of obstruction, conspiracy, and 47 million in offshore transfers, proving abuse of discretion becomes functionally impossible. The appeal will be filed, it will be denied, and the defendant will remain in custody until trial, which could be 6 months away, could be longer, depending on discovery, disputes, and motion practice. The moral stakes transcend this individual case. Every person watching this unfold is asking the same question. Does the system actually work? Can wealth and power be held accountable? Or is that just a narrative we tell ourselves while elites operate under different rules? Today, for this defendant in this courtroom, the answer came back clear. Judge Cartwright didn't deliberate for weeks, didn't schedule additional hearings, didn't give one more chance. She looked at the evidence, applied the law, and rendered judgment. The marshals enforced it. The system functioned, not perfectly, not without the stain of countless other cases where justice banner broke. But in this moment, accountability was delivered swift, certain, unavoidable. This is the inflection point. Either the trial proceeds with the integrity that bail revocation was designed to protect, or we confirm that even the harshest judicial ill interventions are just temporary inconveniences for those with enough resources to outlast them. The defendant sits in a cell tonight, contemplating a reality they likely never imagined possible. The prosecutors are preparing for a trial they now control the tempo of, and the country watches to see if this moment of accountability is the beginning of something larger or just an isolated flash before the machinery of privilege grinds back into motion.